Let me get to the right window. About myself, I'm an American lawyer and have been for about 15 years now. I worked on the plaintiff side primarily, and I've worked on some of the largest cases in US legal history, including the BP oil spill litigation, which lasted for about 9 years. I think it's mostly done now, but it's a long case, and it was a $40 billion settlement. I've been teaching English with Josh for about 3 years now, and I really like talking to lawyers from around the world. I think it's a really fun experience to see how different people communicate and different people uh, express themselves. It's a nice thing. So welcome. And before I continue, if you have questions or comments or need me to slow down or anything at all, the chat window is a very good tool for that, and I read it. So if you have a question, just tell me to stop, and I'll be more than happy to help you out with anything I can. If you have any questions, just let me know. Before we start, in that chat window, as part of Zoom, if you would send me your full name and your email address and your law firm. I think there's only two of you, so we can probably figure it out. But we're trying to find out who's coming and try to follow up and let you know what's going on in the future. Last thing I'll say before we get into the good stuff is legalwriting.eu is our website, is one of our websites, and it has valuable information in many fields of law. And if you'd like to contribute to it, we welcome that. So if you want to get your writing out on our website, we'd love to discuss that with you. Just reach out to Josh or myself, and we'll be more than happy to go. All right. So I start these sessions with a quote of the day. And when it comes to legal jargon, there are a few good ones. I like this one. Never use jargon words like reconceptualize, demassification, attitudinally, judgmentally. They are hallmarks of a pretentious ass. That's one. And if you just Google legal jargon quotes, you'll be bombarded. A famous comedian and songwriter from the US from the olden times named Will Rogers once said, "The minute you read something you don't understand, you can almost be sure it was drawn up by a lawyer." So that's what we're going to try to get out of. And I think contracts are where we find these things more often than not. We're talking about complex language, and we don't need to use these complex words most of the time. However, it is all about knowing who you're writing to. There are some situations where we need very complex language. And our goal here is to keep it as simple as possible. There are terms of art in the law that we have to use. And thank you everyone for sending all of that good info. We'll be in touch with you in the future. Terms of art are phrases that have specific meanings in the law, for example. Double jeopardy is one that you may have heard of. I don't know if you have that in India or in Europe, but in the US, we have this concept of double jeopardy. And you could use that amongst non-lawyers to mean something like any situation that has more than one risk or two risks. But in the law, it means something very specifically, that you can't be charged with the same crime twice, in a very simplistic way. So terms of art are out there, and some of that becomes complex, and we need to know what phrases are necessary and good and what phrases are complicated. So I always say, more than anything, is to write the way you talk. I think that when we write and we try to sound intelligent, we automatically stop writing the way we would try to communicate if we were speaking, and we can overcomplicate things dramatically. It's not necessary, and for the most part, it doesn't communicate what we want to communicate. So I'm going to give you a few minutes here to read this phrase. And we'll discuss a number of problems we have with this phrase. But for right now, take a minute and think about ways that we could shorten this. It's just one paragraph or one sentence even. Yes, one sentence. I'll give you about 5 minutes and see what you can do to shorten this. Anything you want to change, you can answer in the chat, or we can discuss as we go, because I have, I believe, 8 things that I want to change here. So take a minute, go for it. Thanks. Changing the voice of the sentence. Okay, so you want to change from the passive to the active, or yes, that's one thing. And yes, we always try to write in the active voice. It sounds better. It has more authority. Yes, I say 90% of the time, you're right. I'm not sure. I agree with you for the most part. That's not one of the things that we're going to talk about. Janine, do you have any guesses at all?
Yeah, I just wrote in the chat. I would suggest to start with the parties have agreed that this agreement is executed under seal and so on.
Yes, I think that's a good start. Here, we're going to kind of go through this like line by line, and we'll discuss a little bit about words that are unnecessary. If I can get to the PowerPoint, there we go. Okay. For one thing, we don't need a witness to most sorts of contracts. It's an old-fashioned anachronism. It's something from the past that we use, and I'm as guilty of this as anyone when I write lawyerly type things. I think so much of this comes from our law school education. A lot of the books we wrote were in this old style, and it sounds really smart. When you read it, it sounds like somebody is really on the ball and really smart. And of course, we're lawyers. We have egos. We also want to sound smart. So one thing we can eliminate is in witness thereof. And you probably can't see the quote anymore, so you will in a minute. I'll get back there. But so we don't need that. Of course, there are some types of contracts where you do need a witness, but not most of them, at least in American law. Obviously, I don't have the bar license in the UK or India or Austria or anywhere else. I have studied the civil law, but realistically, most contracts don't require a witness, at least not anymore. Okay, another problem. This entire phrase that the parties have caused this agreement to be executed, it's problematic because it's incorrect. Until they've signed the contract, it hasn't been executed. They haven't caused it to be executed. And the parties is another element that isn't really necessary. We'll know who the parties are from the signature block at the bottom and the definitions at the top. Of course, you do need to define who the parties are in many contracts, but in a clause like this, it's not entirely necessary. Okay, again, this idea of something under seal is an old-fashioned thing that isn't really necessary for the vast majority of documents. Okay, this duly authorized representatives is an interesting concept, because it's guaranteeing something in the clause, and it really doesn't need to be there. Promising that your authorized representative is actually authorized really doesn't make it any more likely that that contract will be enforceable. This is a little confusing, I agree. But for the most part, this doesn't add anything to the text of that statement. Okay, and effective date. Again, you'll see that at the signature date or somewhere else in the contract. It's not necessary. So, wait, I think there's one or two more. This I think is one of these funny legal things that we might put in a contract just because it sounds good. We agree to be bound by its terms. Well, of course we do. That's what a contract is. It's parties that are agreeing to be bound. So when you say something like this that's redundant, it's unnecessary, and it makes your contract, while it does make it look longer and more important in terms of number of pages, it doesn't make it any easier to understand or any more enforceable. So that phrase, in witness thereof, the parties have caused this agreement to be executed under seal by their duly authorized representatives as of the effective date set forth above, or if such date is omitted, then as of the latest date of signing, and agree to be bound by its term. We'll talk about this. In reality, this phrase, this sentence, can simply be agreed. And yes, Sidhat says that although sometimes the effective date and the date of signing are far apart and exist post-signing obligations and post-closing obligations. Yes, this is an illustration of what we're trying to get at with this entire course. There are obviously situations where dates need to be more detailed, and things like that need to be spelled out in perfect detail. Certainly, there are times where that can happen. In a sentence like this, it didn't really add anything. Does that answer your question in any way?
Yes, yeah. I think that clears it up. Yes.
Yeah, and as lawyers, we all know that our job is to sit here and nitpick little things and everything we read and see. It's one of our more annoying traits. You can ask our boyfriends, girlfriends, husbands, wives, whatever, and they'll say, sometimes you can just read something and let it go. Stop being a lawyer. But I'm just, with a lot of the slides and the PowerPoints, these are illustrations of our point, not a perfect assessment of it. I will always say that the facts of your case and the needs of your law firm and your partner may require acting directly in opposite to one of our rules, and that's okay. You're smart enough people to understand when you need to follow our rules and when you don't. And so if you have a partner that works above you, they're the person that you need to follow. That's the golden rule. Always do what your partner wants, whether or not it's right or wrong. Unless it's illegal, you should always follow their lead. But you'll get a chance again to try this. This is my joke. My joke page for before we get into the next one is legal jargon from the movie Legally Blonde. I don't know if you're familiar with this piece of art. Let's call it art, but it's about the only legal jargon meme I could find on the internet. Okay, so we're going to do this again, and I'm going to give you some time. We won't go through this one in so much detail, but on this one, I would like you to see how much you can cut from this. without changing its meaning. That's obviously a prerequisite, is to keep the meaning the same. So I'm going to give you 8 minutes on this. If you have questions, feel free to throw them in the chat. But until that time, I will mute myself and let you see what you can cut. We'll discuss afterwards. I have a request to put this in the chat, the text, so you can cut and paste it. 1 moment, and you can absolutely do that. I'll be right back. There you go. It's in the chat window now. That might make it easier to edit. That was a good idea. Okay, I think we're getting close to out of time. If you need more time, please let me know. But I think it's time we should start discussing this. What do we have here? A 9 full line, I think it's a sentence, one sentence of legalese. It's pretty much a mess in my humble opinion.
Can I just have 1 more minute? 1 more minute?
Sure thing.
Thanks. And then I'll post my revision in the chat.
All right, sounds good. All right, we've got Sid Hans. Now we're waiting on Josh and Janine. All right, we have Josh's. Janine, are you coming in anytime soon?
Yeah, just typing in.
No problem. No, no problem.
Oops. It's gone. Oh no. It's just because I'm working with my mobile phone.
Ah, we won't judge you on your typos.
Okay.
And lack of capital letters.
But you don't have to wait for me. It's no problem, really.
Okay, well, we'll take a look at Sid Hans. And it's definitely shorter. I can't quite, I don't think I can do a word count easily here, but it's definitely shorter. You cut out a lot of the meat. I'll start. The undersigned. Is there any reason to not say the parties, or you could even use the party's name if you knew it. If Mr. Johnson hereby extends a lien on the property. One thing we look out for are things like the word hereby is one of these legal words that is not so necessary to communicate how we want to communicate it. I really like how you broke it up into 2 sentences. I think that's a way to simplify thoughts and to really make things clearer. It's more of a this, then that structure. And I like shorter, more shorter sentences than long, complicated sentences. I think that's one thing that is a great tool to do. Josh did the same thing. Good work. We'll discuss a lot of these things later about what we're going to try to avoid. Josh, in the 3rd line, used this phrase: "At any modification shall not affect, impair, or waive the loan agreement." These kind of structures that mean essentially the same thing are dangerous. What are we trying to say when we say affect, impair, or waive? I think that we could make good arguments that there's a difference between waiving or affecting something. Affecting and impairing, on the other hand, are very similar. What's another word that we could use to to encapsulate all three words.
Modify.
Right, change,
Maybe.
modify, alter. Yes, all of those words are a little bit more simple. Uh, and when you have these conflicting words, we'll go through this a little bit later. I actually have a whole slide on it, but those kind of things can be problematic. I'm trying to see if there's anything else we should discuss right here. We might want to look back at these as we move through. With words like modified or modified is a complicated way of saying change. And I think that's kind of what my main point, if I had to spell it out like this, would be simple words, use simple words where possible. And change is the same as modify, and a little bit easier. Might not be the best example in the world, but that's kind of our goal here, is to always choose the easier word. I'm going to go ahead and let you know how I think this can be shortened. I added a blank slide just for drama. Here I noticed I knew the name of the parties for this example. And I guess I should have said that beforehand, but you could have said the party or the lien holder or whoever they were, plaintiff, defendant. But this is all that needs to be written to communicate that giant, unwieldy, really nasty paragraph. And I have a feeling Siddhant is going through the original text now, trying to find out somewhere where I'm wrong. Is that correct?
No, no, I'm just reading it.
So yeah, we're trying to eliminate these complex phrases and use more simple language. That's our goal, and it takes work. It took me a very long time to cut this down to such a short phrase, but I will argue that it means exactly the same thing, at least as a court of law would interpret it. When it comes to cutting, and I'll say this before we move on, it's a really tricky balancing act. If you cut too much out, you lose your meaning of what you're trying to communicate. And if you leave too much in, it becomes unwieldy and clunky and is more complicated than it needs to be. So we're trying to cut the fat and leave the good stuff behind. So let's keep on going, see what we can come up with next.
Yeah, another thing, Jeff, is that your version is a lot quicker to understand and easier to understand for the clients who are not lawyers, and it enables the transaction to be quicker. And I think that's a real important point for people that are typically used to these complex contracts, that we want to simplify that transaction and make that quicker for the parties to agree on. And that I think your version was really, really good for that.
Yeah, thank you. It is easier, and it is always one of our bigger challenges is to communicate with clients. Depending on what kind of clients you work with, some may be very high level intellectuals, some may be less. And so simplicity is easy. I always like to think of when I was a practicing lawyer, my partner was an older gentleman, 75 years old or so. And when I wrote about anything technology based, I had to step back and almost start from the beginning and explain what the internet is before I got into the the important stuff. And so it's about thinking about who you're communicating to and communicating how best to get them the information they need. So ways that we can prevent legal jargon. In addition to the editing practice that we've already gone through, these first two are more or less the same. Is proofreading. Get a friend, a neighbor, anybody you know read your document before you send it. If they don't understand it, if they have questions, you will at least know whether or not you need to fill in some gaps. One of the tools I use, and I use this as a native speaker, is to read my document out loud, is to read it like you're a newscaster, and your natural speech patterns will catch where complex vocabulary makes it difficult to read. Like I said earlier, write like you talk. That's your number one goal, is to, just like I'm talking now. Of course, I would edit my writing like I talk, but this is how I believe written communication should operate. And when you need to use complex legal terms, you may need to define them in whatever way best simplifies your document. We all know, we've all practiced long enough, I think, to know the words and the language I'm talking about. And it's that old-fashioned legal English. It may have worked in the courts of exchequer in the 1700s, but I don't think so. I don't think it's carried on any further. It doesn't need to anyway. Okay. I guess I just basically said this. The reality is that legal documents don't need to be written in this type of language. And we may have some clients that will argue the opposite, saying that, well, this looks like I could have written it. And to me, what I would say in response is, well, then you should have written it. The reality is that legal writing is a challenge. In any style that you do it, we do have to communicate precisely and expertly, but we don't want to make it overly complicated. We want to make it readable and understandable by normal people on the street. So here are 10 phrases and, I guess, things to avoid that you can look at when you're reading and when you're writing. You'll see these things used by lawyers that are far wealthier than you or I. It's what people do to sound smart. One is cliche, and I think we all know a cliche when we see one. That's almost a cliche in itself. But it's something that's overused, and it doesn't show any kind of original thought. These are, I guess, what I'd call these kind of things are a little bit lazy writing. And yes, we all use cliches in our writing because it is a very easy way to communicate something specific. How else would you describe thinking outside the box, for example? Right now, I don't know, other than saying that you being creative in your thought. That's not quite the same. So, of course, we use cliches, but this is something to be watched out for. Even though I'm I guess labeling myself as lazy because it is a little bit lazy writing, something to look out for. The word honorable. I think we all know that when you're talking to a judge that likes to be called Your Honor or Your Highness, whatever they're called where you're from, there are also other places where people use honorable and they use it too much. This is one situation where you need to know who you're communicating with. Being a lawyer is a large part of it is stroking the egos of people with more power than we have. And sometimes your boss may want a title or their respect given to them. Others may be more casual. So it's more about thinking whether or not you need to paint this person as higher and holier than thou. I've seen this written in so many documents that it doesn't help. Of course, if your judge is a traditionalist, use it with reckless abandon. Okay, phrases like pursuant to. And now that you're going to start looking for phrases like pursuant to, you'll see that there are several. And it doesn't help. It doesn't actually tell us anything. Following is a better word to do this. And again, this is a trick that people, lawyers especially, use to sound smart. People pay us money because we can use fancy words like that. We don't have to, especially in our writing. The foregoing. And again, this is just a fancy way to say referencing. Like the PowerPoint says, rarely is there a case when your audience doesn't remember a person or noun that you just mentioned. Doublets. And this is like the one Josh used in his example, to affect, impair, or waive. Cease and desist, cease and desist order. I'm sure that they have this in your jurisdictions, or something similar. And this one is a little interesting because it does actually mean two different things. Cease means to stop doing something, and desist means to not start doing it again. So that one's a little bit tricky, but you can maybe think of an easier word to use there is stop. Stop coming on my land, or whatever it is. In the header there, last and final. This is your last and final warning. Due and payable. That debt is due and payable. These are words that mean exactly the same thing, and it complicates your writing unnecessarily. A single word can do it. A couple others. Let's see here. Of sound mind and body. That would be in a will type situation, I presume. Final and conclusive. Even the concept of peace and quiet. You should not. There's no reason to use a phrase like that when all you're saying is, all you want is to be left alone and to have some quiet. You will see these things throughout the writings that you come across. Some people use them to ridiculous degree, and others use them in a reasonable amount. And like I said before, all of our rules, we're going to put a reasonability standard on them, meaning that if it's unreasonable to follow them, don't. Prior to. There's nothing but different between prior to and before. Why would you ever use prior to unless you're trying to sound fancy? I like prior to. As an aside, I like prior to, and I use it. This is not always my rule, but it can be used too much. I've always thought that a chronology is really the #1 tool for a litigation attorney. And so it's important to know whether things happen before or after, but be a little careful with prior to. In the event that one can be a 2-letter word, if, and it's an old-fashioned phrase that isn't at all writing how you talk. At least I don't talk like that. I'm sure some people do in some more fancy places. In the event that I want dinner, I shall order it from Uber. Hereinafter. Again, this is a whole category of words that you already know what I'm talking about. Heretofore, therefore, herein, blah, all of these words. This is just complicated for the sake of being complicating. Simplify, simplify, simplify. And this is very similar, above mentioned. The previous slide it has a nice point, and it's we shouldn't underestimate our readers. We can't overestimate them either. We can't talk to them like they know everything, but we need to give them a little bit of credit that they'll be able to understand that you're talking about something that's already been discussed in your document. So above mentioned or below mentioned or those kinds of words, avoid them if you can. And finally, poorly used metaphors. These are more or less the same kind of a concept as the issue with cliches. Things like this, they can help paint a picture, but they are a form of lazy writing. It's better to have an original thought than to use old thoughts. Like same with cliches, we all use these things. These are, in essence, the whole point of writing like we talk, because we usually talk in metaphors and cliches. But it's something that we should really, really be careful with when we're writing. It can come off as lazy and not especially intelligent. Okay, so those are my 10. I'm going to send a link via chat, and this is a really nice link. It's more or less a dictionary of legal terms. It's the A to Z guide to legal phrases. And it's put out by the Plain English Campaign, which is a UK organization that has been trying to simplify legal English for, I believe, about 20 years now. And their website is actually quite entertaining. They have if you Google the Plain English Society, you'll find some funny examples of some bad lawyering and some good lawyering. We don't have time for that today. We have about 12 minutes left, and we're heavily ahead of schedule. Excuse me. So if you have questions, maybe time to start thinking about them. Before that, though, we have one last exercise. And I have, let's see here, eight examples of legal jargon. And let's see, I'm going to quiz you here. What does ad initio mean?
From the beginning.
Very good, very good. And I'll say a word about Latin phrases, and we all know that the law is filled with them. Res ipsa loquitur, mens rea. We could go on, and this is the way that we can really sound smart. I like the use of Latin phrases in writing when appropriate. If you're writing to a client that doesn't know Latin or the law, it could only complicate things. If you're writing to a partner, they know what you're talking about, or they should anyway. So know who you're writing to, and if the situation leads you to believe that you can use Latin phrases, I recommend it. I think it's a good way to communicate legal concepts without having to, sorry about that, I had a ding on my computer, apologies. Without having to explain the legal concept. I just don't want to make sure, no more dinging. All right. So yes, very good with that one.
Well,
From
yeah,
the start
Jeff,
of something.
Jeff, if I can just interject, there's two schools of thought on the Latin. And the one school of thought says that the Latin carries over the exact meaning. Whereas when we change it to other languages, whether it's English or another language, then the concept might be changed itself, therefore the meaning, therefore the interpretation. So it's this agreed language. The other school of thought says, well, it means the same thing. Why not just use the plain English version? And this is an interesting thing across linguistics, because in the German language, they've done this thing called Germanization many hundreds of years ago, where they Germanified terms that we still keep Latin. Like, for example, for example, ex gratia, they say zum Beispiel. They actually use for example, and they don't change that, but we use the original Latin. But what's your thoughts on that?
Well, that's interesting. Obviously, if you're writing in English, I would say to use the Latin phrase. If you're writing in German, I guess, use the German phrase. I guess I'm not sure what your question is.
Well, I'm saying that, I mean, the principle is your principle that whenever possible we should use the plain English phrase, or is your principle it depends on who you're writing to, who the audience is? Like last week, know the audience. You know, you said just now, like if you're writing to a partner, you might want to use the Latin because that's going to simplify the communication between you two. Whereas if you're writing to a client, then you won't want to use the Latin because they don't know what you're talking about.
Right. Clearly, I like the Latin because it does describe a legal principle or concept without a long exposition about it. So I like the use of it. Of course, you have to know your audience. Of course, you wouldn't want to throw essentially a foreign language at somebody that wouldn't understand it. So if most of what I think most of what we do as lawyers is try to figure out what the reasonable thing to do is. And so we need to look at how we're writing and where we're writing and determine whether they will know or whether they won't know what we're talking about. That was more last week's class, and I don't want to go through that again. But I think that we just need to use Latin phrases when necessary. You know, really my goal here is to cut down the number of words that we're writing. And so I guess mens rea is a terrible example because there's a very good English translation that's the same number of words. But something like res ipsa loquitur does mean something beyond the direct translation in the law. The thing speaks for itself is true as a translation, but it means more than that in the law. So yes, pay attention and don't confuse people with Latin, but use it where you can. I think it's a good way to communicate several, precise legal concepts. All right, in as much as, I hit the button. Since or because. This is an easy one. Subsequent to. Janine, come on, you gotta get involved here.
Yeah. Yeah, afterwards, next.
Yeah, after. What is an antecedent? This one is a little tricky. This one's pretty hard. Do either of you know what an antecedent is?
Someone who follows, the predecessor.
It is I'm sorry, that's so small and difficult to read. It is the details about a past of a defendant or person found guilty of a crime. Basically, yeah. See, so even for lawyers, we need to look out for our fancy words. Don't feel bad. I had to look that one up too. I kind of knew, but I wasn't 100% sure. What is a legatee or a legator?
Someone who's a beneficiary of a will.
Yes, that's exactly right. It's a person who gives or receives a legacy. Those are funny legal words. Lessee, lessor, all of these or combos of words. In a lease, it's hard to not use a lessee, lessor in a lease. But that's the kind of analysis that we need to make. Can I say I rent to you, or is it that the lessor does this and the lessee does that? These are the things I could speak all day and it wouldn't help. So it's a case by case analysis. What is a novation?
If a secured claim is like replaced by another claim.
You're on the right track for sure. A novation is it's something that replaces an existing agreement with a new one. So if you have, I think, let's say a will is a good example of this. If your grandparents have a will and they make a new will, that new will is also a novation. Does that make sense?
Yeah.
All right, good. As to the complaint, it can mean about or of or by or for or in. As to it's a structure that lawyers like to use. It's referring to. It's that doesn't need to be that complicated. And finally, such can mean that, this, those, or the. I apologize for how small that is, especially if you're on a phone. I'm sure it's simply illegible. I ran out of time to finalize this, but yes, look. It's important that we know the legalese because we'll see it, and we need to understand exactly what it is. But we should also be very careful about how we use it. When we write something or when we say something, our goal is to communicate a message. And sometimes that message is very simple. I like pizza. For us in our work, that can be very complex language that can require pages or volumes or hundreds of pages. The master complaint in the BP oil spill litigation was 1,400 pages long. And I can guarantee it was filled with more legalese than I would ever care to see. But I recommend that simplifying things helps everyone. It helps your opposing counsel that might only have a few minutes to read something and doesn't have time to go all in on a day of reading. It helps everyone when things are simple and easy to understand. And that's our goal. And so thank you so much for your time. I do hope very much that you've enjoyed this hour of legal jargon. Sometimes reading these things in work is one of the more infuriating parts of life. And I hope that you'll start to see your own problems in writing in legalese and start to try to make things just a little bit easier. Thank you again so much.
Thank
and I
you.
hope you come next
Thank
week as well.
you. I'm
Thank you so
sorry for the
much.
problems with my typing. I'm sorry, but
It's
thank you
okay,
very
no
much
problem.
for the input.
I hope we see you again.
Yeah.
Thanks, Jeff.
Bye.
All right, bye.